Brandon L. Garrett is a professor of law at the University of Virginia Law School. His research and teaching interests include criminal procedure, wrongful convictions, habeas corpus, corporate crime, civil rights, civil procedure, and constitutional law. Professor Garrett's recent research includes studies of DNA exonerations and organizational prosecutions. He is the author of Convicting the Innocent, Where Criminal Prosecutions Go Wrong. Professor Brandon L. Garrett, welcome to the Global Freedom Report.
Thank you for having me.
It's a pleasure. You studied painting at Yale College. For those who aren't familiar, Yale College is the undergraduate version of Yale University. You studied painting there, and I understand you even considered a career as a professional artist, and you still show your work on occasion. What are some of the subjects, themes, styles you use in your paintings?
Well, I still paint a little bit, although now that I have kids and I'm a law professor, I don't have as much time as I used to. I painted landscapes for a long time. I did a series of paintings of pizzas.
Pizza?
So, I'm a realistic painter. In college, I got to know the New York art world a little bit and decided that was not for me.
Oh, yeah, now I'm hungry. I grew up in New York, so, pizza heaven.
I actually, my wife proposed to me, not the other way around, and she did it on the Q-train platform at Avenue J outside DeFaro's Pizzeria, where she enticed me with some of the best pizza in Brooklyn.
Oh, that's fantastic. Oh, that's great. That's old home week. You also studied philosophy in college. Now, considering the studies of painting and philosophy, how did you end up as a professor of law?
Well, I actually had been hanging out downtown in New Haven doing drawings, and the people who would usually come up to me tended to be homeless. And they would trade drawings with me. I would give drawings to them. I started volunteering at some homeless shelters in town over the summers and things, and got more interested in some of the legal issues they were dealing with because they had questions about how to try to get welfare benefits so they could try to get housing and get off the streets. A lot of them had interactions of one kind or another with police and had questions about that. So I got more interested in the individual rights issues. I ended up working with homeless people after college in New York City and also sort of trying to help them seek out legal help, and that was my transition to law school.
And I know this is a little off topic, and we'll get into that in a moment, but I'm curious, when you mention the homeless, I find the situation with the homeless to be a very difficult situation to get a handle on, simply because some people are homeless because they wish to be. Some people are homeless because they have no other options. And how do you address such a broad base problem, since you get 10 homeless people, they have 10 different stories to how they became homeless?
There are a lot of different causes of homelessness, obviously. When I was in New York City, I had a walk-in soup kitchen clinic where people would come for help, and I had just two totally different groups of homeless people I worked with. There were families from the Bronx that were living in apartments and, had jobs, were working, and many of them were on the verge of homelessness, and the question was, do you help them sort of cobble together charitable donations to sort of pay 1 or 2 months rent so they wouldn't get evicted? And if they had a job and could things up after that, they could sort of get over that speed bump and stay in their home. No one wanted them to end up in the city shelter system for families where, really awful kids, awful for them. It'd be hard for them to get back in an apartment. So you'd be helping families with unusual emergencies. Someone would get sick, they would miss a few months of work, and all of a sudden they would be on the verge of becoming a homeless, which no one wants. On the other hand, I was working with kind of your stereotype of Bowery. The Bowery, I think, is more fashionable now in New York. Bowery drunks who had serious substance abuse problems, serious mental illness problems. Some of them were in rehab programs. Some of them probably should have been and were not. And those people had just all sorts of different issues. And, people, it was going to be hard to imagine them working any.
Are panhandling or anti-panhandling laws fundamentally unconstitutional?
Well, some of them have been struck down depending on their written. The people I was working with really were too mentally ill to hold down panhandling. Right? that was a problem, right, where a lot of the mental health hospitals got emptied out in this country.
Yeah, well,
and you had people with just such serious problems who had needed real medical help. I think a lot of cities have done a better job of trying to sort of fill in the gaps and provide services to those people that really just are a danger to themselves and others. But there's still a lot to do, issues.
Yeah. Your book, Convicting the Innocent, Where Criminal Prosecutions Go Wrong, chronicles what appears to be a pattern of bad verdicts and mis-sentencing. What can you tell us about the extent of the problem?
Well, my book is about a really interesting and unusual group of cases, and they're the tip of an iceberg. We can talk about what that iceberg might look like, but we don't know. I went back to look at what went wrong in the first 250 cases in the U.S. where DNA testing cleared someone post-conviction, often years after they were convicted. These were people convicted of relatively serious crimes, mostly rape, some murders, types of cases where DNA testing can shed light on the question of innocence or guilt. A lot of these people were convicted, really by definition, in the 1980s before DNA testing was common at the time of trial. And years later, when that technology came around, starting in the 90s, these people were exonerated one after another. And many of you have probably heard of these cases in the news. Every few weeks there's a big exoneration. We've all heard about the work of the Innocence Project in New York, other Innocence Projects on the country, freeing these people. But obviously in most criminal cases there is no DNA that can be tested, or if there is, it can't tell you anything about who the perpetrator is. And so in most cases there's no DNA to answer the question as easily as in these cases. So I wanted to know, but how about these easy cases? What actually happened? So I went back to look at the trial transcripts and the records from these cases, which really weren't very easy to find. It took years to gather all the original records to try to get a handle on how did these innocent people get convicted in the first place.
And what did you find? Why is this happening? Why is justice not being served for some?
What I found most haunting about these cases was that you might think these guys are innocent. Come on. It must have just been that a weak, flimsy case managed to slip by the jury. But actually, when you look at these trials and you hear what the jury heard, you'd think that maybe, you convict these same innocent people in a heartbeat without the benefit of DNA. The cases seemed uncannily strong at the time because of the ways that the evidence was contaminated. So a number of these people confessed, and what the jury heard was that these people confessed in detail using specific facts that only the killer could have known. We now know it couldn't have happened. They heard eyewitnesses who said at trial that they were confident, they were absolutely sure that this was the guy who assaulted them. Well, it turns out that earlier when they looked at the lineups, they hadn't been so sure. That's not what the jury heard at trial. These jurors heard about forensics, which supposedly showed that, only this person or his twin brother or something, could have left a hair like that, or this is the only person who could have left a bite mark with those kinds of details. It turns out that those forensics have been discredited, but what the jury heard appeared really strong. Same with jailhouse informants and some of the other evidence. So these cases appeared strong, but it was because of the way that the evidence was exaggerated at the time of the trial. That's what makes these cases so troubling.
Well, what actually now, as I listen to your explanation, I find it troubling to think that the courtroom has been turned into a stage area where all you really have to do is make a presentation that the jury will believe what you want them to believe. And it doesn't really matter what the facts are. It doesn't matter what the real evidence is. Just what happens in that courtroom. And I mean, now you've got me wondering, what can we do about that? Does educating the jury make any difference if they're only exposed to incomplete information in the courtroom?
Well, again, I think that's what's so terrifying. Most of our criminal procedure is premised on the idea that, these problems get solved in the courtroom. After all, there's a right to a defense lawyer in this country if you can't afford one, and your lawyer can cross-examine the other side, and the crucible of the courtroom will bring the truth to light. So what these cases show is that if the evidence is contaminated long before the trial, if the police feed facts to someone in an interrogation room so it seems like they knew facts that only the killer could have known, it's impossible for the lawyers to counter that later or even unravel what happened. But unless there's a real record, for example, when looking at the confessions, unless there's a video of the entire interrogation, it's impossible to know who said what in the interrogation room. The only witnesses are the police and the suspect. And the jury can't unravel that. The judge can't. The prosecutor has no way of assessing what happened. He'll believe the police if they say that this guy really confessed. And so what it really shows is that, you need protections earlier on, because the jury it's not fair to expect the jury to know what the status is of forensic science principles, to know what happened in an interrogation room months before, know what happened at a lineup that they didn't see. So it really calls into question the way that we document evidence in our criminal process.
Yeah, and you're right. I mean, you would not, even an informed jury, you would not expect them to necessarily question that to that degree, that kind of presentation. It's quite disturbing. I watched a video recently in which you're speaking about the problems in the judicial system. You implied that the problems arise because of, call them misdeeds, by a minority of prosecutors, police, judges, and so forth, and that most of the people who work in the system, the judicial system, have good intentions. Could you clarify what you meant by that?
Sure. So, for example, there was a lot of unreliable and bad forensics presented in these cases. Were these forensic scientists coming into the courtroom trying to frame innocent people? I'm sure they weren't. From what I can tell, looking at other cases, they testified the same way all the time. Just so happened that overstated, unscientific testimony contributed to innocent people's convictions too. But they also frequently overstate the science in cases where it may just be icing on the cake and the guilty person is convicted. Right? It's bad either way, right? They should be accurately telling the jury what the scientific evidence shows. But in the same way, these eyewitnesses got it wrong, and they were uncertain early on about the person that they picked out in a lineup. By the time of trial, they became certain. Bad lineup procedures were the cause of this, but those same bad lineups are used across the board. Fortunately, most of the time, the right person is probably identified. We don't know how often they make errors. It's not bad faith on the police that they were using bad lineups for so many years. Initially, at least, they just weren't aware of the psychology and how important it is to not contaminate an eyewitness's memory. Now they're aware of it, and now it's really troubling that they haven't shaped up the way that lineups are done. Now we know just how fragile the memory is of an eyewitness. But I don't think that police are trying to screw up lineups. I just think that they're set in their ways, and for a long time they didn't realize how devastating the social science was and how important it is to be careful about the way you do lineups. So, if it was just a few bad apples, lying cops, lying forensic scientists, then these cases would look terrible. Innocent people were framed. But they would be, an isolated problem. A few bad apples. Unfortunately, I think this is really more of a bad apple problem, that the same bad procedures were used in these cases as were used in countless other, which hopefully most of the time bad procedures were used and they got a guilty guy. But we don't know that, because in most cases you can't do the DNA.
And that's a problem, because I say I'm a Jeffersonian. I believe better to have 100 serial killers go free than one innocent person incarcerated for even one day. So I'm kind of a strict Jeffersonian in that respect.
Obviously, it helps police. Police want to get guilty people and free the innocent. Better lineups, better forensics help them get guilty people too. So I don't think we even have to, sacrifice one for the other. That's what's so powerful about DNA in these cases, obviously. These are lucky cases where DNA not only freed the innocent, but a lot of the time, 40% of the time, they track down the guilty person using the DNA as well.
I want to ask you about prosecutors. Now, in my opinion, prosecutors have been unlawfully granted immunity from pretty much anything they say or do during the performance of their jobs. This has resulted in prosecutors fabricating evidence, intimidating witnesses, and even lying to judges in open court, yet nothing is ever done about such blatant violations. Now, I understand that your sampling is limited to only those cases that, are DNA evidence cases, but you also said at the beginning you kind of got a sense of patterns out there. So I just want to ask your opinion. To what degree do you believe prosecutorial misconduct contributes to convictions of the innocent?
Well, we know that it certainly played a significant role in these innocent people's cases. And really bad lawyering on both sides played a role. A lot of these people just had terrible, unqualified defense lawyers. They couldn't afford a lawyer. So just to be fair and place blame on lawyers on both sides. The most common claim that these people brought in their efforts to try to free themselves before they got the DNA testing were claims based on prosecutorial misconduct. So these people were crying right and left that prosecutors had engaged in misconduct. The most serious misconduct a prosecutor can commit in this context, the context of wrongful convictions, is to hide evidence of innocence from it. Those are commonly called Brady violations after the Supreme Court case Brady versus Maryland, which said that, look, based on principles of due process, the state just can't hide evidence of innocence and then put someone to trial. And, of course, the problem with bringing claims of prosecutorial misconduct is that if evidence of innocence is concealed, it may never come to light, right? Prosecutorial misconduct can sort of conceal itself. And so we will never know how much evidence of innocence was hidden in these cases and remains hidden to this day. So it's really surprising, actually, how often it did come out that evidence of innocence was hidden in these 250 cases. There are several dozen of these exonerees who argued on appeal that prosecutors had hidden evidence of innocence. Just a handful got relief. But what was really interesting is that since these are somewhat high-profile cases, because DNA technology was new and there was press attention to these cases when these guys got out, almost all of them are men, and the reporters looked into these cases. Many of them filed civil rights lawsuits and got discovery and finally got to look at the prosecutor's files. It was really incredible how many of these cases involved Brady violations coming to light years later. In 22 cases, it came out that forensic analysis helpful to defense had been concealed. And in other cases, it emerged that informants had secret deals with the prosecution, and that's why they lied. There are amazing cases where it turned out eyewitnesses didn't just get it wrong, but they were hypnotized. The defense was never told.
Wow.
Some cases where prosecutors or police had evidence that strongly supported the defendant's alibi. And look, a lot of these people said, I have an alibi. I was at home. I was with my family. Sometimes police talked to the witnesses, and they actually supported it, and that was hidden. There's an amazing one. Clarence Elkins discovered years later that police had notes from an interview with a man who lived right next to the murder site who made all kinds of self-incriminating remarks. They sort of ignore him. Turns out years later the DNA matches him. He was the killer.
Wow.
So there are all sorts of amazing examples that came out. There's an amazing one where a witness, in Pennsylvania, he said, look, come on. There's an R written under his photo in the photo array. R for rape. That's why she picked it. Well, years later, it actually came out that prosecutors never told the defense that the detective had actually coerced her and pressured her into identifying him. And you're going to get in serious trouble if you don't identify Doswell.
Well, now,
who knows how often that happened, and it just never came to light. But the examples that we know about are just horrifying. Well,
and that's the thing. We know about many examples of it. So from the standpoint of a professor of law, how has it come to be that in a system that is supposed to be justice for all, prosecutors are known to do this kind of stuff, and they get away with it, and nothing changes? How did we ever arrive at prosecutorial immunity for criminal violation? Well,
you put your finger on what keeps prosecutors from being held accountable. If these people, these innocent people, and obviously very few people can successfully prove their innocence, very few people have DNA, but just these DNA exonerees, when they try to bring lawsuits, they can't sue prosecutors for anything that prosecutors do related to the courtroom, related to their trial. The Supreme Court has said that, look, common law prosecutors were traditionally immune, so we will interpret the civil rights statute as preserving that common law prosecutorial immunity. There's very little legislative history. It's the main statute that people use to bring civil rights cases dates back to after the Civil War. It was passed to protect people's constitutional rights. There wasn't a lot of legislative history. Nothing was said about prosecutorial immunity in the record, but the court sort of created this doctrine. And the court has gotten more and more aggressive about defining the scope of prosecutorial immunity. Your listeners may have seen the news reports about this Connick decision, Connick versus Thompson, this decision from earlier this term, where the prosecutor, he didn't sue individual prosecutors that are immune. He sued the entire office because Harry Connick Sr.'s office in New Orleans had policies that just failed to train any prosecutors about their obligations to turn over evidence of innocence to the defense. And in fact, when they talked to Connick and supervisors, they just didn't understand that they had that obligation. And in that particular case, they withheld a forensic lab report that showed that the perpetrator had a different blood type. So it was really clear evidence of innocence that would have supported him. And he spent 13 years in prison, including some of them on death row in Louisiana for a crime he didn't commit. He gets out, he files a civil rights suit. He's given a substantial damages award, and the Supreme Court reverses it, saying, there isn't enough evidence that prosecutors should be held responsible here because they're lawyers and they understand their duties to comply with the Constitution. They don't need to be trained, and so you shouldn't hold the office responsible for not training.
Now, you just brought up an important word, training. Prosecutors, judges, police, they all have one thing in common, different job descriptions, but they all are trained by the same government to do their jobs in certain ways. Wouldn't it be fair to say that the actual training of these people is the reason there's a systemic problem that is certainly far beyond what you have chronicled in your narrow scope with the DNA cases?
Well, of course, police are trained all the time on use of force, discharging their weapons, but that's because whenever an officer's gun goes off, they know that there's a chance they could be sued. Right? They know that they're going to be held accountable, that the community will know that they discharged their gun. Now, obviously, there have been problems with different police departments in terms of use of force, but they know that there's at least a strong possibility that they could be held legally accountable. That is not true of prosecutors because they're immune. So if an innocent person goes to prison and the prosecutor tried the case, their training is never going to be scrutinized. Right? There isn't going to be a press conference the next day asking, what do these prosecutors know about their Brady obligations? There may be no consequences at all. And in addition, there's the time factor. It took years for these innocent guys to get out of jail. By the time the DNA freed them, there was often a new prosecutor in office. Right? All the people who worked on their case may have since retired or moved on.
Or even died by then. Yeah.
Actually, and part of the reason it took so long was that where the same prosecutor was in office, they often refused to do the DNA testing. Some of these guys didn't get DNA until there was a new prosecutor elected who was willing to reopen these old cases and wasn't sort of stubbornly insisting that these people did it. All these people waited a long time to get the DNA. That's really changed. But again, if you can't sue prosecutors when they really do make egregious mistakes, there's no real accountability mechanism. It's also very difficult to sue defense lawyers when defense lawyers do egregious things. It's a failure of the bar all around to make sure that there's accountability and training. And
I think it goes to the primary objectives. The objectives. I mean, if the objective is justice, okay, then you get one approach. If the objective is to win, you get another approach. Today, in the courts, it's like the attorneys are fighting each other. They're playing a game, and each is trying to win at all costs. And justice, true justice, sometimes suffers for that. Whatever happened to the objective of rehabilitating criminals? Like these days, you talk about use of force. These days, it seems as if even the most minor, tiny infractions are met with fully outfitted SWAT teams, armored personnel carriers, and military-style weaponry. What about rehabilitation and reintroduction into society as useful members?
It's amazing to me that, obviously there are budgets, we don't programs to rehabilitate people or reintroduce them into society even after they've, gotten out, have been cut back, although there are new efforts to try to do that. But how about innocent people? You figure we can all agree that if someone really didn't commit the crime, that we should do something, when they are exonerated. There are actually fewer support services available to the innocent because they aren't being monitored for any reason. They're not on parole. They've been freed. And so, these guys get their, bus ticket and a denim jacket or whatever, and they're walked out of prison with no support. And obviously, people who are in prison who are guilty can be damaged by being in prison. It's intended to punish them, and it can be a horrible place to be. Those people, often have PTSD-like symptoms. Maybe they cope over time. Obviously, there's a lot of recidivism among people who get out of prison. But how about the psychological effects of being in prison, knowing all along that you're innocent? It hasn't been studied enough, but a lot of these guys, when they get out, really need serious help readjusting, having lost the best years of their lives, and there's just nothing available.
And to those who value justice, it's very frustrating because there's no obvious answer to it. All right, well, here we go. If you could make, in 90 seconds or less, if you could make immediate changes to the judicial system to make it function correctly, what would you do? And for the sake of this question, you are omnipotent.
I like this question. First, I would want all interrogations to be fully videotaped so that we know exactly what goes on in the interrogation room. All eyewitness lineups should be double-blind and also videotaped so that there's documentation and also protections in place to make sure that no one is suggesting anything to the eyewitness and that it's a fair procedure. Tens of thousands of cases are resolved using eyewitnesses every year, and we're just not sure how accurate they are because they aren't done right. And all crime labs should have independent auditing and real quality control, which they don't have now. DNA testing should be available to anyone who could use it to potentially prove their innocence. And we should really rethink the way that informants are used in our courts, particularly jailhouse informants that have such strong incentives to lie.
Would you mess with prosecutorial immunity?
Yes, I think both prosecutors and also, defense lawyers need to have more accountability. Right, there needs to be some accountability when serious errors come to light. There's no other industry in America where doctors can be sued for malpractice. Right, other government officials, if they do something serious, they benefit from some qualified immunity, some benefit of the doubt, but there's room for accountability.
Excellent. Excellent. We're out of time, Professor. It's been an absolute pleasure and an education. My guest has been Professor Brendan L. Garrett of the University of Virginia Law School. His book, Convicting the Innocent, Where Criminal Prosecutions Go Wrong, is available on Amazon.com. Is it in bookstores?
It's in bookstores.
It's in bookstores as well. Professor Brendan Garrett, thanks so much for spending this time with us. We really appreciate it.
A real pleasure to meet you on the air, and thank you again.
My pleasure. Professor Brendan L. Garrett, Convicting the Innocent, Where Criminal Prosecutions Go Wrong.